I want to actually begin just first by thanking Paul and Helen for organization. A special thank you to Matthew for the work that he's done in kind of moving us around and organizing, and in particular to Leslie for the tremendous work she always does with the CSRS in organizing. A conference interested in the governance of religious diversity in a number of national political legal cultures. And this is a paper that is, in a sense, about the role of education in that governance. But I'll say in a sense, because I actually end up coming to a different point. Canada's legal and political history on issues of religious difference is, of course, a very long one. It's an interesting one, and notably it's one that has had issues of education always at the center of the debates. That centrality of education has quite notably not abated since the Charter coming in. It's actually intensified. We've seen education be more of a flashpoint. And so a remarkable portion of our recent cases on issues of religious diversity have been generated out of issues around education, be it the presence of religious symbols in education contexts, or the penetration of equality norms into education, or the design of public education, which is what I'm going to be focusing on a bit more. And so there's a long, very interesting history here, which is something that I canvass and analyze in the paper, but I'm not going to be able to address at length today. But for today's purposes, the key point is that I've been puzzling for some time about what can be said about that correlation between education cases and religious diversity. Right? This is a transnational question, maybe more transnational in some senses than many other issues. The JFS case in England, the Laozi case in Italy, issues of design of education have been central in debates about difference in Israel, Canada, the US. But beyond saying simply that what we teach our children is important, which is obviously true, I'm interested in what of theoretical import can be said about that tethering of religious diversity and education. And so this conference has given me that opportunity to write up and think a little more about that issue under that ACT umbrella of governance of religious diversity, which is actually what I think these cases are all about. So I want to say a few things about what I see as being at stake in this interaction between religious education and diversity. But ultimately, as I hope you'll see after a somewhat winding path, the point that I actually led to thinking a bit more about this is a point about conceptual distinctions that can be drawn within the notion of state neutrality. So I want to end up saying something about state neutrality. But let me begin with saying a few words about the deep stakes of these education cases, why I think that they are so frequently at the heart of religion and diversity matters. And I actually want to pull from a little piece of Hannah Arendt's thought for this. In her 1954 book, Between Past and Future, Arendt argued, she had a chapter called The Crisis in Education, really interesting chapter. And the chapter is ostensibly a critique of constructivist approaches to childhood education, a view that children had to be discovering the knowledge rather than particularly directed to the knowledge. Arendt saw that approach, that constructivist approach, as a crisis. He called it a crisis of responsibility. Why? For Arendt, education sits at this critical point in the formation of both the individual, the child, and of society, which she calls the world in this piece. And Arendt's central theme is that in education, adults must take responsibility for the world as representatives of that world into which children are coming. Right? But they take responsibility not to insist on its appeal. In fact, they might disagree strongly with the world that they're reflecting. Instead, we have to take responsibility for the world, she says, so that the young have the chance to create in it, to respond to it, to renew it. And constructivism, in her view, washed our hands of any responsibility for that world in which we're bringing children. It banished them from the fact of a common social world with which they had to reckon. It deprived them, in so doing, of a chance to renew the good and to create something new, something totally unforeseen. And it washed our hands of that. It deprived them of this by letting go of the world as we know it, by disowning our knowledge of the world, and thereby disowning them in an important way. So if you'll indulge me, let me just read the last little bit of her essay. So this is her words. Education is the point at which we decide whether we love the world enough to assume responsibility for it, and by the same token to save it from that ruin which, except for renewal, except for the coming of the new and young, would be inevitable. And education too is where we decide whether we love our children enough not to expel them from our world and leave them to their own devices, nor to strike from their hands their chance of undertaking something new, something unforeseen by us, but to prepare them in advance for the task of renewing a common world. And there's a lot of interest and of provocation in that quotation, right? Education's about responsibility, about representing the world to youth. But let me offer you another interesting passage from this chapter. Gets us a little bit closer to the themes at the heart of thinking about contemporary challenges of religious diversity and education. In describing the key social and philosophic place of education, she describes school in the following way. Normally, the child is first introduced to the world in school. Now, school is by no means the world and must not pretend to be. It is rather the institution that we interpose between the private domain of home and the world in order to make the transition from the family to the world possible at all. So adding to the layer of thought in her first quotation that I read, we see here that there's some crucial way in which she suggests we can think about education as a portal between family or community and the world at large. So in this view, education is about making a world, about shaping a creative, ethical actor in a world that we see. It's perhaps one of the key pivot points between family and society. It's a site for preparation for the world, and in complex ways, it's the place for the cultivation and exercise of freedom. And this is what I see as being at stake in these debates about law and religion in the context of education. This area becomes a kind of lightning rod for religious diversity and equality issues, in part because education is about the creation of social worlds. It's that reality that led in Canada to schools being the centerpiece of a French-English settlement in our constitutional structure. Education is a place where culture happens, where community is transmitted, is created. And that's true not just for religious communities, right, but for the state as well. And this is not a claim just that children are our future, though I suppose that's true. It's the specific claim that it's through the political act of education that we induce new social worlds, and that it's through education that the ethical exercise of freedom is made possible for the next generation. And so these contests that take place within school settings are conversations really about the world for which we're taking responsibility, for the world in which we're inducing children. And we must read cases about education, I think, in that context. And it's with that in mind that I want to turn specifically to a recent Canadian case that I think gives some insight into what is at stake in the intersection of religion and education. And it's called SL against Commission Scolaire des Chaînes. So it's sometimes called SL, sometimes des Chaînes, sometimes other things. And this is a case that arose in Quebec, and you'll hear Matthew say more of interest on this point. So in the paper I do a little more work on the specific Quebec history here, which is important. I just can't do it here. So here's the basic factual background. In the complex unfolding of the secularization of Quebec's public education system, which is a long arc to it, in 2005, the Quebec government moved to replace remaining Catholic and Protestant programs of religious instruction with a compulsory common education program for all public schools called the Ethics and Religious Cultures Program, the ERC. And as it relates to religion, the ERC sought to foster understanding of several religious traditions, but with an emphasis on the particular religious history of Quebec. Now, in May of 2008, Roman Catholic parents of 2 school-age children in Quebec requested an exemption from the ERC for their children on the basis that this program infringed their and their children's religious freedom rights. Ultimately, what they were claiming was that this course interfered with a right that they had as parents, their ability to pass on Roman Catholicism to their children by teaching about religion in a specifically Roman Catholic way. And they said the ERC interfered by teaching about religion in a way that claimed to be neutral, that taught Roman Catholicism alongside a number of other traditions, and that this program was therefore not neutral because it was a program that induced a kind of relativism. The ministry refused their request for an exemption in a couple of decisions, and those decisions were confirmed by a couple of courts before they found their way to the Supreme Court of Canada. And the Supreme Court of Canada dismissed the parents' appeal, holding that the project of exposing children to multiple religious traditions did not in itself breach the religious freedom rights of these parents to do what they claimed they were required to do, which was to pass on the precepts of Roman Catholicism to their children. It was a matter of legal doctrine. This decision itself, as a doctrinal question, is really not all that interesting. It was an evidentiary decision. It said you hadn't shown evidence that this interfered with your religious beliefs. The court holds as long as it doesn't hinder one or another vision of religion, exposing children to a, quote, comprehensive presentation of various religions without forcing the children to join them could not in itself produce a form of indoctrination. It wasn't a form of indoctrination. They say any confusion, any dissonance between the teachings at home and the teachings at school was inherent in living in a diverse society, a fact for the world, about the world for which education had to prepare students. Now, although I generally concur with the court's sense of the decision in this case, I disagree on one statement they make, a statement that I think is a way into why education is such an important area for thought about secularism and religious freedom. I think that it's wrong to quite so baldly state that public education, and specifically education about varieties of religion, is not a form of indoctrination. So suggested from the Arendt references, education is always, all in some form, a project of indoctrination. That's what makes the field of education such a flashpoint around the world for issues of religion and secularism. These cases about public education are very much a contest over the formation of the child. And that formation is an intrinsically political act. So the much more challenging, provocative question at play here, the question I feel is at the heart of these issues, is so long as we can agree that disparagement of religion or dismissal of the beliefs of families and communities cannot be permitted, as we can agree on that, if the state honors that admonition, does it have any legitimate claim to the hands-on formation of its citizens? And on preparing the children on the worlds that they're going to be inheriting and for which they are going to have responsibility. Now, the court refuses to say the following, but let's assume that at least to the extent that SL might have wanted her children to grow up with one view only of Catholicism, with limited exposure to other religious traditions and communities who claim a contrary truth. The ERC did in some way interfere with those parents' ability to transform or to transmit religion as they saw fit. But with that concession, it's at that point I want to draw out another feature of the decision, and with it a significant conceptual point about what it is that we ask from the state and from the governance of religious diversity. And so in the last 5 minutes or so, I think the part I want to draw out is a notable feature of the court's approach in SL, and it's the centrality of the claim of state neutrality. State neutrality, they say, is the governing principle for religious freedom and equality. Beyond that narrow evidentiary ruling that I said isn't all that interesting, okay? The preoccupation of the court is its desire to vindicate both the notion of state neutrality and the neutrality in this instance. They say, joining with the parents, neutrality is crucial in this setting, but that in this case it was neutral, right? This program was neutral. And the court indicates accurately, I think, in my view, that that notion, that language of state neutrality has been central to how, they say, Western states create this space for free religion and equality. At one fascinating point in the decision, the court concedes that perfect state neutrality might not be received as neutral for a community, but then immediately backs off from that, redeeming in the next paragraphs the sense of state neutrality as important as a legal concept, and establishing in a number of moves the very strong pedigree of neutrality in Canada, state neutrality in Canada. So the court's response to the issue is really to, along with the parents, assert that the case is about state neutrality and to vindicate that concept and its centrality, to just deny that this was an instance of non-neutrality. Now, needless to say, great goods can be achieved under the standard of neutrality and even-handedness, absolutely. But that's where the thread of thinking of what's at stake in religious education, I think, for me, wants to sort of come together with this question of state neutrality. The idea of state neutrality has tremendous purchase and appeal in juridical and political and scholarly conversations about pluralism, about religious diversity. But these education cases, I think, point to a slippage, at least a distinction worthy of identification and exploitation, something within the concept of state neutrality that I think we don't have our hands fully around. And this is it. Does state neutrality demand that the state be neutral about its own value, about the conditions of its own health and its own ethical flourishing? Does the claim for state neutrality demand that the state be neutral about itself? And these education cases point me to the need to draw that distinction in the concept of state neutrality. The distinction I want to draw as being between state neutrality on matters of religion and the neutrality of the state as to the conditions of its own flourishing and the needs for a good civic democratic life together. My claim is that in concession to the demand for state neutrality in matters of religion, there's something of a danger or an instinct towards giving a little too much to that concept. Enthralled to the idea of state neutrality, there is a danger, I think, of creating a kind of inert state, a public life that can't act in the interests of its own flourishing. And this is the difference, you might say, between a kind of agnosticism and an openness, or about engagement and respect on one hand, and a kind of thin libertarianism on the other. The SL case really could have looked pretty different in the way it was written. This is an interesting way to engage with these cases. What might it have looked like? It might have read as a defense of certain needs of a pluralistic public sphere. The cultivation of intercultural knowledge, practices of toleration, respectful interaction across differences are foundational civic skills that are, I think, in today's society, equal in importance to knowledge of things like math and sciences and things like that. In Israel, interestingly, the country is facing a kind of unimaginable social crisis that's arisen from the failure to properly give account to the needs for civil society of certain kinds of education in the society. And so let me just, in closing, in the last little minute or so, reach back to Arendt here. Remember what she wrote about the role of education between family and world. She says, "School is by no means the world and must not pretend to be. It is rather the institution that we interpose between the private domain of home and the world in order to make the transition from the family to the world possible at all." Now, when that world is factually one of competing claims of truth, of religious diversity, of sexual diversity, of rich cultural difference, I think there's a case to be made that the state has a legitimate interest, even a responsibility, in equipping the child for this transition from community and family into world, for the sake of that common world that they're going to inherit and take responsibility for. And so, though SL presents a case in a long arc of debates about education, and it helps me to understand what's at stake in those debates a little more, it actually brings me back to this concept of wrestling a little about what we actually mean when we're demanding state neutrality. Now, there are conceptual points that need to be fleshed out in our morning paper. What do I mean by state here? What's captured in state? And that's important, really important. And I do worry about the immodesty that can settle in, the dangers of immodesty that can settle in with the vindication of the state's capacity to speak to its own needs. But it nevertheless seems to me crucial that we look a little more carefully at the precision we bring to bear on concepts like state neutrality. And I find it interesting that although I think this is at play in many of the decisions, education disputes, I think bring us most centrally into the heart of this kind of debate. So I look forward to chatting more about it. I'll leave it there.